Well, I guess we'll go ahead and get started. I am a 26-year member of Local 710, and I am a 4-year steward. I represent drivers, preloaders, and full-timers, part-timers, everybody. A lot of people don't know that we have the right to FMLA, and I've been helping people use this for years. I help more men get on FMLA than anyone else. So as for working women and union activists, we wanted to provide some education on an issue that falls on a lot of working women, which is caretaking for family members in addition to ourselves. I've been helping members access FMLA to protect their jobs for years, and I'll give you an example of someone in my building. This isn't just for having a baby. This can be used for migraines, a back condition, anxiety, PTSD. Men, women, anyone can use it. Your employer doesn't decide if you qualify, your doctor does. I had a member who is full-time. He had to have his gallbladder removed, which caused him to have some gastro issues, and he was having to call out a lot. UPS was starting to threaten his job. They would come to me and ask me to talk to him about his attendance, and he finally discussed with me, and it was really uncomfortable. I felt really bad for him, what was going on. He had no clue that he could use FMLA. And at that point in time, he had told me that he had another condition. I was able to explain to him that you could have FMLA for more than one issue. So to try to get FMLA for both of the issues, if they were causing him to call off, which was causing him the issues. He ended up needing the max number of FMLA days for both of these issues. I was able to help him get it applied retroactively, so he couldn't be punished, and they had to wipe his attendance record clean, and his job was saved. He's now doing fine, and if they overwatch him, I'm ready to help him. At the end of this, we'll be sending out forms for UPSers on this call. You'll need to go through the Hartford group to apply. I'll put the Hartford group and FMLA phone number in the chat. Christy, it's your turn to give your example.
Hi, my name is Christy DeCenzo. I'm from Local 251 out of Providence. I'm a little bit different than UPS. I work for Rhode Island Hospital, and I represent nursing staff as well as everyone in between. We have maintenance, we have housekeeping, anything that's an applied trade we represent. So mine is a little bit more personal into why I'm on this call. 2 years ago in May 2020, I had to go on FMLA personally for my father. My father actually passed May 10th of 2020. So when he was going through hospice, I needed to be with him. I was his power of attorney, even though my mother's still alive. She didn't and couldn't take the responsibility of doing that. So I had applied, and we have a third-party administrator called the Reed Group. The Reed Group actually denied my first attempt to get FMLA, and I had to go and reapply and show them that, in fact, I was qualified. The number of hours they said I did not have, which was not true. I am a part-time worker. I'm only a scheduled 24-hour worker, but I work upwards of 60 to 70 hours a week. I'm a single parent. So I definitely qualified with the hours, and they were not trying to give me what I was entitled to. So I was eventually able to do so. When I was out for 6 weeks, I was able to help my family, help my mom get back on her feet and be stabilized. And that prompted me to want to help other people and learning about FMLA, what you need to qualify. And if the employer tells you no, most of the time they're wrong, especially if you have a third-party administrator is part of the issue, that they think they know what's going on and they don't. So that's the reason I'm on this call. That's the reason I got involved. I've been a union steward now for 3 years, and actually I am out on workman's comp right now. So I am doing this on my own time. But if it wasn't for Local 251, I would not have a job, because the union actually has 2 years that I can be out on workman's comp. And right now, currently, I'm fighting with my employer to pay for my injuries that I received while on the job. So that's why FMLA right now, and anything having to do with workers, is important to me. We go into next.
Thanks a lot, Christy, for sharing all of that. And I cannot believe what you're going through at work. Joining us today is a retired union side labor attorney, Gabrielle Semel. She's a longtime friend of TDU and a fighter for the working class. She's filed 2 big class action lawsuits against Verizon for violating FMLA rights.
Okay. So first of all, I want to thank you for inviting me. It is really an honor to be doing this. And I really enjoyed preparing for this with Leanna and Jennifer and Christy. And Jennifer and Christy, thank you for sharing the experiences you've had with FMLA. So I want to just explain, there's a reason why I want to explain this. I am a labor attorney. I'm not an employment lawyer. Employment lawyers are usually the ones that do FMLA cases, but in union situations, it's a little bit different. And what happened at the phone company sounds like it's still happening everywhere, which is employers hate the Family Medical Leave Act. And I'm going to talk a little bit more about that in a few minutes. But when it was passed in 1993, the phone companies in the, you can tell I'm from New York from my accent, but the phone companies in New York and New Jersey, which were 9X and Bell Atlantic at the time, they instituted all these policies that made getting and applying for the Family Medical Leave Act extremely difficult. And so people began filing grievances with the union and complaints, and we realized there was a problem. So I and a few other attorneys spent a lot of time pulling together all the documentation. We brought 2 massive class action lawsuits against 9X and Bell Atlantic at the time. Now they're merged into Verizon, but at the time they were separate companies. And we brought these class action lawsuits that we won and changed the policies and procedures for thousands and thousands of workers. So the reason why I want to tell you that is that it's not just the individual rights, they're also our collective rights. And the only way we find out that the companies have these system-wide violations is if you make sure you let others know. So my word to all of you, and I'm really heartened to see how many of you are on this workshop, is that you learn it, you use it, and you make sure that your coworkers know it and use it. And that if there are problems, it gets reported to TDU people, it gets reported to your union stewards. And that if you're in a workplace in which they've created impediments to people getting their legal rights, that the union might be able to do something about it that would affect thousands of workers, not just individual cases. Now, the Family Medical Leave Act is an extraordinary important statute. It is the most pro-worker statute that was passed in this country in a long time. It was passed in 1993. Most people think, you hear the name, Family Medical Leave Act. This is a statute that's about leave for medical reasons. It is not. It is a statute about protecting your job. Always think about it that way. What the law does is that it protects workers who get sick or who have close family members who get sick from losing their job or being disciplined or being discouraged from being with their family. It is a job protection bill. Now, because it's a job protection bill, employers hate it. They hate it. I know that the phone companies hated it, and based on what Jennifer and Christy just said, and also the number of people who are on this call, I assume that they still hate it. And the reason they hate it is because they don't like to think of workers as human beings. They want to think of you as part of the machinery, right? So, and they want the machinery to work. They want you to be where they want you to be, when they want you to be, and they don't want to have to deal with your problems. The Family Medical Leave Act says, no, you can't do that. Workers' health and the health of their families come first, and their jobs have to be protected. So because they hate it, they often find all sorts of ways to discourage people and make it more difficult to get. Don't let that happen. And so I'm glad you're all here. We're going to talk about the basics for the Family Medical Leave Act. But I want to say one more way in which employers hurt people using the FMLA. And I'm sure you've all experienced, or maybe some of you have experienced it, which is they badmouth workers who take it. And they say, and you might have heard a supervisor says, oh, you know, they're always out. They're abusing this. They're making it harder for everyone else. They do not know anything about why the person on FMLA is out. They are not entitled to know. You do not have to give a diagnosis. And even if ultimately your doctor tells a doctor for the company, or that some other a part of the company knows what the reason is because of another medical benefit, the supervisors don't know. It's a violation of HIPAA for them to know. They don't know, you don't know. And so if somebody badmouths another worker to you, just cut them off. And you can also tell them, which we'll talk about later, that if you think there's something fishy, there's something else that the employer can do, and I'll get to it. Just remember, employers hate it, and they try to make it hard, and they don't want you to know your rights. Know your rights, use it, make sure other people know their rights, and don't let them badmouth other workers. It's divisive and it's bad. Okay, that's my introduction. Now we're going to do a little quiz. And the quiz is a series of 4 fact patterns to get you to think about the FMLA. And different members of the Women's Caucus are going to read the questions. You're going to get an answer sheet. It's anonymous. Nobody knows how you answered. At the end of the talk, we'll go through the percentages and see how many people got it right, how many people I tricked. But the point is not to trick you or make you feel that you're not smart or anything. The point of it is to make you think like, oh, I don't know the answer to that. And maybe you'll pay a little bit more attention when we get to that section. So, okay, we're going to do the quiz now, whoever's going first.
All right, quiz number 1. Mary was sick with a bad cold. She stayed in bed on Saturday and Sunday and felt too sick to go in on Monday and Tuesday. On Monday, she called her healthcare provider, a nurse practitioner, who prescribed 5-day course of antibiotics. Mary returned to work on Wednesday. Does her 2-day absence from work qualify from FMLA?
No.
We'll
Now we
put up a
need the-
poll and then you can answer that way. There we go. All right, there we go. There's the results.
Okay, we're not going to talk about it now. We're just going to go to number 2.
Oh. Number 2, okay.
What?
Christy?
Thank you. John gets migraine headaches. They often require him to lie still in a dark room for a few hours. On Wednesday, he had to leave work to go home and lie quietly with a mask over his eyes to block out the light. The next day, he left okay and returned to work. Does John's half-day absence on Wednesday qualify for FMLA?
Yes.
Again, we're doing the same thing. If you can answer the chat.
And we need the answer sheet. Okay, great. Oh, that still
Didn't
says
come
quiz
up.
number 1. Okay.
There we go. All right, Reese, you ready for question number 3?
I am.
Awesome, thank you.
Number 3, Maria works for a chain drugstore. The chain has 6 stores in New Jersey where she works. There are 27 employees in her store. The next closest store is 100 miles away and has 25 employees. Are Maria and her coworkers eligible for FMLA?
Yes.
All right, McCarthy, quiz number 4.
Gabrielle was approved for intermittent FMLA leave in February when she was off of the job for 2 days due to her chronic condition. At the time of her first absence, she had worked for the company for more than 1,250 hours during the prior year. In March, Deborah was off from the job again because of her chronic condition. The employer calculated Deborah's hours worked over the prior 12 months and determined that Deborah no longer had 1,250 hours and denied Deborah's FMLA request. Is that correct?
I'm going to say yes, buddy. Sure. Sure.
All right, perfect. We'll go ahead and have you guys type some questions in the chat box. And Christy, we're going to turn that part over to you.
I
I don't think we're up to the Q&A yet.
No?
Go back.
Okay, perfect.
Go ahead. Go ahead, Gay.
Okay, all right. So hi again. So I'm going to now speak for about 15 minutes. I'm going to try to keep it down to 15 minutes about the basics of the Family Medical Leave Act. So this is a basic workshop. There are little complicated things that I'm not going to talk about. I really encourage everybody to look at the Department of Labor website. There's a link to it on the information that the Women's Caucus is going to give out. And there's just a ton of information. So, and it's very, very accessible. So I highly recommend it. So the first question is employers. The first thing you have to figure out if someone is covered by the Family Medical Leave Act is whether or not their employer is covered by the Family Medical Leave Act. So there are two, the way we divide up employers in this country is between private sector and public sector. And the law in most labor law related questions is different depending on whether you're a private sector or public sector employee. I assume that most of you are private sector, but possibly some of you are public sector. If you're in your employer is a private sector employer, that is, it's not a governmental entity, to be covered by the Family Medical Leave Act, the employer has to have 50 employees or more, and that includes managers and supervisors within a 75-mile radius. So if they have more than 50 employees, but they're scattered at distances that are farther than 75 miles, workers for that employer are not covered. In the public sector, there is no limitation to the number of employers or a radius issue. All federal, state, and local governmental employees of local governmental entities, including schools, are covered by the Family Medical Leave Act. So once you figure out whether or not you're covered, and I assume most of you are, based on the employer, you have to figure out if you yourself as an individual are covered. So to be covered by the Family Medical Leave Act, you have to have worked for that employer for 12 months. They do not have to be consecutive months. So, for example, if you worked for an employer for 6 months, for some reason took a leave and then came back and worked another 9 months, you would be covered because you worked more than 12 months, as long as all of those months fall within a 7-year period. You can't use service that goes further back than 7 years. The other thing, once you know that you've worked the 12 months that are required, did you have enough hours in the previous 12 months? So you have to have worked 1,250 hours in the previous 12 months. So that was the issue that Christy raised. So she had some outside vendor group who didn't really have her time, but had sort of the time for part-time workers and said, no, you don't qualify. She knew that she worked 1,250 hours because she knows what the FMLA says and she knows how much she worked. So she could challenge it. There's one thing that's really, really important. You've got to be your own advocate and you've got to make sure that they're doing it right. Christy was right. These third-party administrators they're hired to create more obstacles for you. So there are some those are the basic formulas. Your employer has to be covered and you have to be covered. You've worked at least 12 months in the last 7 years and you've worked 1,250 hours in the last year. There are slight differences if you work in the airline industry. If you work in the airline industry, there's a whole little fact sheet for airline industry workers on the Department of Labor website. Check that out. So that tells you if you're covered. Okay, now what kind of conditions are covered? The big thing that most FMLA leave for is your own individual serious health condition. Serious health conditions are defined in the following ways. There are 4 different categories. I think there are 4. Any overnight stay in the hospital, even if you're not incapacitated for more than 24 hours, but if you stay in the hospital overnight, that qualifies. Incapacity, and this is the big one. This is the one that I think this is the one that most people get FMLA for, which is incapacity for more than 3 days, 3 consecutive days. You do not have to be out from work. So for example, if you're incapacitated for a Saturday and a Sunday and a Monday and Tuesday or part of Tuesday, you have been incapacitated for more than 3 consecutive days. Now, but you need more than that. So if you're incapacitated by a cold and you don't get medical help, it doesn't qualify. But if you are incapacitated for more than 3 consecutive days, whether or not you were scheduled to work on those days, and you have medical appointments, more than 1, or prescription drugs, you're prescribed a drug for your condition, you qualify. So, for example, if you have a bad cold and you're out for 4 days, it doesn't qualify. If you have a bad cold and you're out and you don't seem to get better, and on the 2nd day or the 3rd day, you go to your doctor and the doctor listens to your lungs and says, I don't like what I hear here. I'm worried about a secondary infection. I'm going to give you antibiotics. You now have a medical visit and a course of treatment, and you've been incapacitated for more than 3 days, and you qualify. Okay, the other big category that is really important and incredibly helpful to people is a chronic condition. So if you have a chronic condition, migraines, asthma, back problems, gastrointestinal problems, psychological issues, you qualify as long as you are getting medical help at least twice a year. And the fourth, is pregnancy, which includes prenatal care and required bed rest. Another category, so these are the things, these are the serious health conditions for yourself. The same definition of serious health conditions applies to a close family member. So if you have to care for a close family member with any of these four conditions, the condition that the close family member suffers from requires you to take care of them, then your leave qualifies as well. So a close family member is defined as a parent, a child, a spouse, a domestic partner if you qualify for a common law marriage in the state that you're in, and someone that acted in locus parentis to you as a child. So what does that mean? Or for whom you acted in locus parentis. So that means somebody that cared for you in the place of a parent, or for whom you care for in the place of a parent. If when you were growing up, your aunt took care of you for 6 years or 3 years because your mother was off in the military or your father was off in the military, and that aunt needs your help, that qualifies. All of these, the birth of a child or the adoption or a placement in foster care of a child, a bonding period applies, and it applies to both men and women. The benefits of the Family Medical Leave Act. The Family Medical Leave Act provides 12 weeks of protected leave. So if you go over 12 weeks, it's no longer protected, but you are protected for up to 12 weeks. If it's military related, it's 24 weeks. FMLA leave can be taken all at once in a block of time. If you have surgery and rehabilitation, you're going to be out for 2 months, you can take the whole 2 months all at once, or it can be taken intermittently. It just has to be certified. If you are on FMLA leave, the employer has to continue giving you all the benefits that you would get if you were on any other leave, healthcare, other kind of benefits, etc. You cannot be disciplined in any way for taking FMLA leave. You cannot be fired or dismissed. You cannot be stepped on an absence control plan. You cannot be demoted. You cannot be refused a transfer. The big negative about the FMLA leave is that it's unpaid leave. If you have personal time that's paid, like vacation or sick pay, you can elect to take vacation and sick pay concurrently. And another bad thing is the employer can elect for you to do that. So that if the employer says, okay, you're going to be out 2 months, but I see you have 4 weeks of vacation pay, you're going to be considered on vacation at the same time. You'll get your vacation pay, but you won't have any vacation time left when you come back. How do you request FMLA leave? When you call or do whatever you do, every employer does this differently. When you notify whomever you notify that you're going to be out sick, you say, I'm requesting FMLA leave if you think that it qualifies. Many employers now automatically just send out FMLA papers because they know that if an employee gives enough information to notify them that that employee is entitled to FMLA leave, even if they don't ask for it, then the employer, then there's no time limit on the employee getting back the certification period. It doesn't start until they get the certification papers. So very often employers just send it out. If there's a leave that's more than 3 days, they just send it out, even if you haven't never asked for it. Employers have to notify you when you ask for FMLA leave, or they suspect you're entitled to it. They have to notify you of your rights within 5 days, and they also have to give you a certification form. The Department of Labor has a standard form. If you want to be really aggressive about protecting rights, check the form you get against the one that the Department of Labor uses as its model form. How much does it deviate? Does it violate the law? That was one of our big issues. The certification forms that the phone company was using was misleading. It told people information that was wrong, and it asked for information that they weren't entitled to. Once you get the form, I said you have 15 days to get it back. Your healthcare provider has to fill out the form. The healthcare provider can be a doctor, a nurse practitioner, a PA, a psychologist, a chiropractor, a clinical social worker. As long as they're certified in their field, any of these, a dentist, any of these people qualify. If they fill out a form and it's incomplete, you get another 7 days to get it fixed. You do not have to give a medical diagnosis on this form, and the employer cannot ask you for it. But the doctor or the healthcare provider does have to provide certain specific information. How long you will be out, and that you have a continuing course of treatment, or if it's for intermittent leave. Here's one of the things that becomes problematic. Usually the forms ask, how often will you be out for intermittent leave? And if the doctor says, or the healthcare provider says once a month, and then you exceed once a month, then they often deny it. And then there's like another battle. That was one of the things that the phone companies were doing. Tell your healthcare provider to put down a range. They shouldn't say once a month. They should say approximately 3 times a month, or 3 to 5 times a month, so that you're protected and you don't have to go through lots of battles when you end up needing to take an additional day. If the employer suspects abuse, they cannot call you in and question you. They cannot ask all sorts of questions about what the diagnosis is. They have a remedy in the statute, and that is at their own expense, they can get a second opinion healthcare provider to examine you, and you have to comply with that. If their healthcare professional does not agree with your healthcare professional, then at the employer's expense, they can get a third healthcare professional that both sides have to agree to, and that person is a tiebreaker. There are some exceptional situations in the airline industry. I mentioned that, and you should, if you're working in the airline industry, please go on the Department of Labor website and look at it. In the military, there are other additional more information other than just that you get 24 weeks. I believe there are other things. I've never dealt with a military situation, so I don't really have any experience with it. There is something called a key employee. If the employer has a key employee, then no one else does that job, and they're going to be out for 3 months, the employer is allowed to put someone else in the job and then have an equivalent job available for when they come back. And there are also unique things about how intermittent leave is worked out for teachers. If you're a teacher and you need intermittent leave, again, go on the Department of Labor website. Wrongful denial. Okay, so I've told you what you're entitled to. You know what you're entitled to. You apply and you get denied. What do you do? Well, I hope I've convinced you that the first thing you do is you talk to your steward, because you want to make sure that the stewards in your place are paying attention to this. It's not just you. If they're denying you, they may be denying somebody else. The union can go to them and say, look, we've got a pattern here. We want this fixed, or maybe the union will ultimately decide, if they can't get satisfaction, ultimately bring a lawsuit. But make sure your union knows about it. Check the company paperwork. The paperwork will tell you what the appeal procedure is. I assume that Christy did that. Follow the appeal procedure, because if you don't, you're considered to have waived your appeal. Ultimately, you might, depending on who you are and what the situation is, you may bring your own lawsuit. Oh, you should file a complaint with the Department of Labor, or you may bring your own lawsuit. How to file a complaint with the Department of Labor is on the Department of Labor website. It's pretty easy. There are other sources of protection for FMLA-like issues. Your union contract may provide benefits that are better than the Family Medical Leave Act. The Family Medical Leave Act is a floor. It's not a ceiling. The union, if it's powerful enough, can bargain improved terms and conditions. Many states have passed what's called mini FMLA laws, and they may be better than what the federal statute provides. Also, some states have paid sick leave provisions for people who are on FMLA. So there are other sources for these rights. Become an FMLA expert. The resources are there. Make sure you let your steward know, make sure you let TDU know, and make sure the union ultimately knows. We will lose these rights if we don't fight for them. I am finished. I don't know how long that took me, but there's one thing I didn't talk about, which is, because it's too complicated and involves math, and I didn't want to get everybody bogged down in it. There are different ways that the employer uses for calculating when people accrue new FMLA leave. And as long as there are 4 different ways, as long as they do it consistently throughout the company, that's fair. They can't just use it to prejudice one worker because they say, oh, for you, we're going to use this so you don't have any more leave. It's when your 12 weeks accrue. Some employers do it at the beginning of the year. Some employers do it at the beginning of a fiscal year. Some employers do it based on your individual dates. The employer should, in the FMLA papers, it should tell you how they're calculating it. If you think there's something fishy, go on the Department of Labor website and learn about the options and see if they're doing it wrong. Okay. I hope that you all felt you learned something. And now let's go to the quiz. Do you have the questions?
We posted. Do you see it?
Can you bring them up? If not, I'll just go over them again. Leanna?
It's up on the screen.
Oh, okay. All right. Just came up
It's up on
mine.
the screen.
Okay. So the first one is that Mary was sick with a cold and she was incapacitated on Saturday and Sunday. They weren't work days for her, and she felt too sick to go into work on Monday and Tuesday. So she was incapacitated for more than 3 consecutive days. She qualifies, assuming that her employer is covered. Her provider was a nurse practitioner. Nurse practitioner is a qualified healthcare provider under the FMLA, and the nurse care practitioner prescribed. She saw the nurse care practitioner, or she had a telemed appointment, something, and was prescribed a 5-day course of antibiotics. So she was incapacitated for more than 3 consecutive days, and she had a continuous course of medical treatment. She qualifies. Okay, how did everybody vote? All right, I fooled most of you. 57% of you said no, 14% of you said yes. Some of you thought you needed more information and some of you didn't know. So the only way she wouldn't qualify from this fact pattern is we don't know if her employer was covered. I didn't say that. So that is definitely a piece of information we would want, but the rest of it is clear. You do not have it, your days of incapacity do not have to be work days. So she qualifies. Okay, the next one. I hope you all know that now. All right, the next one had to do with John's migraines. Okay, John gets migraines and they often require him to lie in a dark room for a few hours. He had to leave work to go home and quietly put a mask over his head and to block out the light. The next day he felt fine and returned to work. He qualifies if he is being treated for migraines. This could be the first time that he requests it, but he's still gonna have to be certified. He can ask for it, and as long as his employer is a covered employer, and as long as he has enough hours, he would qualify if he sees a doctor at least 2 times a year for migraines. And the fact that he was only incapacitated for a half day would qualify under intermittent leave. Okay, quiz number 3. Oh, wait, what were the answers? Okay, most of you said yes, some of you said no, some said depends, and others said not sure. I think that we don't really know enough. We don't know if he's getting treated by a healthcare provider at least twice a year. But if this came to you, if you're a steward or an activist and somebody comes to you with this, you would say, yes, I think you qualify. You're going to have to get a certification. You have to see a doctor at least 2 times a year. Okay? Next quiz, number 3. Maria works for a chain drugstore. The chain has 6 stores in New Jersey where she works. There are 27 employees in her store. The next closest store is 100 miles away and has 24 employees. So the question is, does she qualify? Let's see what you all answered. Unfortunately, probably not, because there are no other employees within a 75-mile radius. The reason for this, every statute goes through a sausage making process, as you probably know. And so this is an accommodation to employers who say, I don't have enough employees that are nearby that I can transfer over to do her job or his job while they're out on the FMLA. So that was a concession to employers. Okay, most of you thought they qualified. Now you know there is a 75-mile radius requirement. Okay, question number 4. Okay, the company denied Deborah's FMLA. Oh, wait a second. Sorry, that's the question. Deborah was approved for intermittent FMLA leave in February, and she was off the job for 2 days due to her chronic condition. At the time of her first absence, she had worked for the employer more than 1,250 hours during the prior year. In March, Deborah was off the job again, and because of her chronic condition. The employer calculated her hours worked over the prior 12 months from the date of the second absence and determined that she did not have 1,250 hours and denied her FMLA leave. Okay, is that correct? That is incorrect. Once you qualify for 12 weeks of FMLA leave for the next year. And it doesn't matter if you drop below. You might drop below because you're going to be out for FMLA leave. So you qualify once and that's good for the next year. Let's see what you did, guys. Was the answer.
answer should be on the screen.
No, it's not on my screen.
57%.
Why don't you just
Sure,
tell us
yeah.
who it is? Oh, there it is. Okay. So I asked if that was correct, and most of you said no, and you were correct in saying no. Good job. Okay. So I am finished with my presentation and the quizzes, and I think the next thing is Q&A. Is that right?
Yes, it is. Christy, do you have some questions you want to address?
Yeah, so I was reading some of the questions that were in the chat. I just want to address a few things. First of all, I'm retired Navy after 22 years. I did active duty for 10 years, and then I was 12 years reserve when I have been working at Rhode Island Hospital. I retired in 2019. With that, any of those laws that you need to worry about for the military, you can look at the National Labor Board. It's right on the website. It's called U.S. Service Members, and it's employment and reemployment after deployment. It's right there on the website. If anyone hassles you with any time, your rights and what you're entitled to, they should not be harassing you, because you should let the union know, especially when it comes to deployments. I used to deploy every summer for 4 to 6 weeks and never had a problem, because they know that they don't want to mess with the military and trying to go against that. The other thing I was reading was, Gay was saying that it depends on your state on the laws for the private sector. I can tell you in the state of Rhode Island, I actually helped create the law for the private sector and under 50 workers in your area of employment. I actually am a survivor of domestic violence, and I'm actually a volunteer for the Rhode Island Coalition Against Domestic Violence. And here in the state of Rhode Island, we just passed it in 2020. It was signed in 2019, and then in 2020 issued into law. So for the state of Rhode Island, come January 1st, everyone will receive 5 days. We call it sick and safe time. So that's above and beyond FMLA, and was originally created by survivors such as myself and 2 other sister survivors. And the problem was happening is, again, a women's issue, that when you're a survivor of domestic violence, you're not able to go and get your documentation done with your doctor. You're not able to go and get a restraining order. So those things were created for the state of Rhode Island. But it's depending on what state you're in, is depending on how many, what the caveat is for the private sector. So, and then I was just reading some of the other things.
Christy, let me just add something. The state you're in has no effect on your right under the federal statute. It's just that the state you're in could affect you having additional rights.
Correct.
If you have a state law that gives you additional rights, just the way Christy said, in terms of paid leave, which is terrific. Great work.
Thank you. So this is, as I stated, this was one of the other reasons that I've been on this call, was because it is important to me. I am a working mom and I'm out in the workforce. I came from working family and blue collar. And as I said to Gay, my mom is retired from Verizon, so I appreciate all the work that she's done with them. I'm gonna go into some more questions that we were looking at. Some people were asking, I saw there was one for a kidney transplant. I believe Gay touched on that and saying, you need to go to your provider and have them fill out the paperwork correctly. If you have any questions, you can certainly reach out to your local stewards. But again, that has to do with your doctor, and it's private information, and no one can actually have any recourse on it as far as penalizing you for doing so. So that's private, again, information they can't ask. Some of the other ones I was seeing, chronic illness. I'm going to pertain this again to myself. I have a chronic illness as well. I have Crohn's. So you can, again, go to your private doctor and they can put in, I know, I'm going to share personally, I know my doctor is big on how many days I actually am allowed to go out. He says, typically right now I'm pretty much in remission. So he will give me a week to 10 days. He said, if we need to increase it, then he will revisit the paperwork and we'll go over it again. So trying to see some UPS, you do have to reach out to the Hartford. That was some personally that I saw from UPS. Again, I work in a different industry. So each industry and each contracts has their own laws and their own issues with each contract. I know for 251, we have some really great supporters. Tony and Paul are really good in making sure that their members are covered and not harassed. If you're being harassed, you need to go to your steward and you need to say who's doing the harassment and what manager, what supervisor is doing that harassment. And they really need to be investigated. That should not be happening for FMLA. Again, as Gag keeps saying, it is a private information. It is not their right to know.
I just want to tell Christy and everybody else that years before I became a lawyer, I was a telephone operator. So I know exactly what it was like and how you can be really tortured by these people.
Well, I'm going to share with you guys. My mom, actually, I was telling her that I was doing this, and she said to me, a funny story really quick. She said to me, when she first got married in 1973, they asked her personally if she was going to start a family.
Yes, they asked the most embarrassing questions. I actually testified at the EEOC about this, but we won't go into all of this. We'll have a private conversation.
But this is why I was born with this, fighting for the worker. My mom never actually wanted to become a manager because she was all for the worker. And she has a business degree, a bachelor's in business. So I'm trying to read some other ones. So just get involved. And the other thing that we're going to talk about is the National TDU Convention. So I went to TDU Convention in October, and it really behooves you to get involved, find out who's not only in your local, because I don't know everyone in my local. There's 2,500 workers just in my hospital alone. And that's not including, we have bus drivers, we have UPS workers, we have other people in other industries. So I was pulled into TDU and it has been nothing but helpful. And so that's the other thing that we're going to talk about. I want to see some other. And then I also saw some other questions as far as sick time, where can they pull it from? So it's depending on your contract and where you either have sick time or vacation time. And again, you have to discuss that with your steward, make sure that you have the information correct, because it is based off of your contract. I know when I went out for my father, I had over 90 hours worth of vacation time. So that's where I pulled it from.
Okay, well, we're going to go ahead and wrap up the questions. We are going to have a form at the end that you can fill out questions, and we will try to, we won't try, we will get back to everybody with answers. So just make sure you fill that out. With that, I'm going to go ahead and turn this over to Reese.
Can't hear you, Reese. You're muted. Thank you. There you go.
Okay. Can you hear me
There
now?
we go. Yes.
I just started going.
Saw your
So-
mouth moving.
So if after today's Zoom, you don't feel that these policies go far enough, we have the power to change things by continuing to organize our unions and workplaces for better protections and stronger contract language. That's why I'm a TDU activist, a proud one. And when I go out to the gates talking to members, I teach enforcement of our contract by educating our members on their rights and crucial understanding of the contractual language and laws. I teach members how to support one another, because education is power. Education is protection. Education is your support when you are cornered alone. And as a TDU member, you will be immersed with educational opportunities like this and information to protect yourself and to share with other Teamsters. We're in for the fight of the century, and we're building an educated army to bring to the table. And so right now we're running a join promo because it's that important. You get 2 years for the price of one. And if you get 3 of your coworkers to join TDU, you get $100 off the convention registration price. And that convention, you don't want to miss it. It's a great deal, but more importantly, it is multiplying the army that we're going to need to get the contract that we deserve. Thank you.
And now we're going to hear from Carthy. She's out of Boston, local 639.
No, I'm not out of Boston. I'm out of Washington, DC, the nation's capital.
Oh,
My last name.
that's what I just was reading, so I
Ah,
guess
there
I
you
had a
go, there
typo.
you
I
go.
apologize, Karthi.
All righty, I'm Karthi Boston, ISC member of TDU, elected to office here at TDU. I just want to pitch for the convention. I'm going to say it's the greatest convention. If you've never been to any conventions, you do not want to miss the convention coming up in October. We're the hottest thing on the market compared to the Labor Notes Conference. If you've ever not been to Labor Notes, a plug for them as well. All right, please sign up. I can tell you it was my first time I attended TDU convention last year. I was a part-timer at the time. I have been 16 years with UPS as a part-timer. And I got to meet so many people at that convention. It was amazing. And in 2 years, I became a business agent with my local. So it speaks for itself. If you put in the work, you're gonna get back the output. Come to the convention, register, get to meet all these cool people. They're so loving, they're so kind, and everyone matters at TDU. All right, so register for that convention. I'd like to also put a plug for our scholarships. We have a scholarship section coming up for those who can't afford. Last year, I could not afford my own way to go to the convention. I was a broke ass part-timer working at like 20-something an hour. My God, starvation wages. I hope I'm on that committee to negotiate those part-time wages. Anyway, throughout that time, I was sponsored to actually go to the convention by a senior member of TDU. And today I'm paying it forward, and I'm also sponsoring someone from my local who's involved in getting fundraising efforts. Last time when I went to the convention, I was alone. I had nobody with me. There was not one member of Local 639. I came back to my home front and I say, Beth, we're gonna get people to come to the convention. My buildings, the buildings I oversee right now are involved in fundraising efforts, raffles. They're doing barbecues, their own thing to get to the convention this year. And we're expected to maybe have at least 15 to 20 people from our local attending the convention. How rewarding and how fulfilling. So that scholarship opportunity that I'm going to put forth, we're raising funds, we're putting money on a joint effort. TDU does have a scholarship link. We'll post in the chat tonight and today. Please donate. All right, if you can make it and you need help to any extent, we don't actually choose you have to pay for your own ticket, but we do give you discounts in terms of anything, in terms of housing and accommodation and fees. We try to match that and try to give you discounts there. So do donate if you can. Every little bit helps. We're gonna post it in the chat today. If you can, spread the word that TDU convention is hot. All right, thank you guys. And you did a great job, Jennifer, by the way. Awesome job.
Thanks so much, Karthi. I also
You're
want to
welcome.
say that I'm a proud TDU member, and it's definitely life-changing, the sisterhood and brotherhood that we have through here. A lot of people to lean on when you need somebody to talk to and answer questions, most definitely. Just so you guys all know, thanks for coming. We appreciate everybody giving us your time today. We'll be sending out a form by text after the call. So fill it out and we'll get in touch if you want to be in touch about FMLA in your workplace. Any questions, yeah, reach out to any of us. I'm personally on Facebook. If you have that, feel free to friend request me. I'm sure you can look any of us up and just ask questions that way too. Thank you so much, everyone, and look forward to seeing you at more workshops.